The Washington Post reported this week on the Department of Homeland Security's use of a secretive legal weapon to target people who question the Trump administration's brutal immigration crackdown. It's called an administrative subpoena. Unlike traditional subpoenas, which require a court order by a judge or on behalf of a grand jury, administrative subpoenas can be issued by federal agencies without approval from a judge or a grand jury. The Washington Post reported extensively on one such case. It's a remarkable story. You should read the whole thing. According to the Post, last October, a 67-year-old named John, a retiree in the suburbs of Philadelphia, decided that the America he believed in would not make it if people like him didn't speak up. John, who asked the Post not to use his last name out of concern for his safety, said he had come to that conclusion after reading a news story about DHS's case against an Afghan man that it was seeking to deport. The Afghan, whom the Post identifies as H, had begged federal officials to reconsider, telling them that the Taliban would kill him if he was returned to Afghanistan. H had sought asylum in the United States as he was a vocal proponent of the U.S. military presence in Afghanistan and worked for a U.S.-backed nonprofit. Counterterrorism experts say that Afghans who flee to the United States are often viewed by the Taliban as spies, placing them in particular danger should they return to that country while the Taliban is in power. John told the Post he found the situation, to which he had no direct connection, unconscionable. So he conducted a quick search on the internet. He found the email address of the lead prosecutor on the case and sent a brief message to that prosecutor urging him to reconsider H's case. Addressing the prosecutor, here's what John wrote. Quote, "Don't play Russian roulette with H's life. Err on the side of caution. There's a reason the U.S. government, along with many other governments, don't recognize the Taliban. Apply principles of common sense and decency." End quote. John finished the note, signed his first and last name, hit send, and hoped his plea would make a difference. 5 hours and 1 minute later, John was watching TV with his wife when an email popped up in his inbox. He noticed it on his phone. Google, the message read, has received legal process from a law enforcement authority compelling the release of information related to your Google account. Listed below was the type of legal process, subpoena, and below that, the authority, Department of Homeland Security. That's how it all began. Just over 2 weeks later, Homeland Security agents were at John's door. After receiving the email from Google, John began to seek legal advice, which was complicated by the fact that the subpoena issued for his information was not provided to him. To make matters worse, John told the Post that Google had given him just 1 week to file a motion to quash the government's demand. That would have to be done in federal court. While the U.S. government has used administrative subpoenas for decades, expanding and becoming more controversial in the post-9/11 era, this feels different. Privacy and civil rights groups say that under Trump, Homeland Security has weaponized the tool to strangle free speech. John was actually fortunate. Google notified him. Companies are not legally required to do so, and many simply don't. A Google spokesperson told the Post that the company notifies users unless they're legally prohibited from doing so or in exceptional circumstances, such as when someone's life is in jeopardy. But John's case is far from unique. Transparency reports show that Meta and Facebook have received record numbers of subpoenas since Donald Trump began his second term. Google reports more than 28,000 subpoenas in the administration's first 6 months, a 15% increase from the previous 6 months, while Meta reports more than 14,000. Neither company distinguishes between the different types of subpoena in their disclosures, but the trend is evident. Meta, Microsoft, Amazon, Apple, and Snap say they all notify their users of administrative subpoenas, while T-Mobile and TikTok say they only notify users when required to do so by the law, according to the Post. When DHS agents showed up at John's home, they showed him the email and they asked for his side of the story. The agents said they didn't know anything about this administrative subpoena, but had been instructed by DHS headquarters in Washington to interview him. Eventually, the agents agreed that John had committed no crime after he told them he found the prosecutor's email through a simple Google search. John did secure pro bono representation by ACLU attorneys who argued that the government is violating a statute that limits how administrative subpoenas can be used for immigration enforcement, and that the government targeted John for constitutionally protected speech. One of those attorneys told the Post, the goal isn't always prosecution, it's intimidation. Quote, "It doesn't take that much to make people look over their shoulder to think twice before they speak again," said Nathan Freed Wessler, one of the ACLU attorneys. That's why these kinds of subpoenas and other actions, the visits, are so pernicious. You don't have to lock somebody up to make them reticent to make their voice heard. It really doesn't take much because the power of the federal government is so overwhelming. Power of the federal government is so overwhelming. In a statement to the Post, the Assistant DHS Secretary, Tricia McLaughlin, noted that Homeland Security investigators have, quote, broad administrative subpoena authority under the law. The agency did not answer questions about John's case or its broader use of administrative subpoenas. John was never charged with a crime. John didn't impede an investigation. John just sent an email, and that alone was enough to bring federal agents to his door. For more on this, I'm joined by Joseph Menn. He's a cybersecurity reporter specializing in hacking, privacy, and surveillance. He's covered this beat for more than 2 decades. I'm also joined by our great friend Melissa Murray, a professor of law at NYU and MS Now legal analyst and the host of the Strict Scrutiny podcast. Good morning to both of you. Thank you for being with us. Joseph, let me just start with you. I was gobsmacked reading this article. You probably weren't. You probably knew this stuff happened. So tell us about the part about how they can get into your stuff that easily.
Well, administrative subpoenas are very powerful depending on how the company that receives them reacts. As you said, some of the major companies at least notify the targets of the subpoenas, and some don't, and some won't say. There's some, in general, the telecommunications companies didn't speak to my colleague for this story, but they have a pretty bad record of cooperating quickly with those sorts of responses. Financial records too, credit card companies, pretty much any company you can think of. And we're so awash in data now that just an immense amount can be compiled without you ever knowing about it.
Melissa, I get it. I get why the government needs certain powers to do certain things. I remember after 9/11, people saying, well, you know, if you're not doing anything wrong, you have nothing to worry about, that the government has expanded powers to get into your stuff. I think this is a pretty clear example of somebody who wasn't doing anything wrong. I'm a little surprised that it's that easy to get a subpoena into people's personal information.
Well, the origins of the administrative subpoena, Ali, are basically to allow law enforcement to have the flexibility and the nimbleness to move quickly when there are exigent circumstances. So, for example, if someone's life is in danger, or if someone is being trafficked, or if there is terrorism, again, you note the rise in the use of this mechanism post 9/11. They weren't intended to suppress dissent. Again, what counts as an act against the government is obviously subjective, and some governments take a broader view, and maybe we are in that moment right now. It seems like we are. But right now, it seems that the government is using this and using it not necessarily to fight crime or to enhance public safety, but to minimize dissent. What John was doing in that Washington Post story was simply expressing an opinion to the government. That's the hallmark of American democracy, the idea that citizens can be skeptical, they can raise their voices and be critical of the government, and there aren't repercussions for simply doing that. That is your right to do. And here, again, there may be no legal consequences for him in the end, but the process is kind of the punishment here. And he's fearful. And in future instances, he's likely to be deterred from raising his voice again. And those around him are also likely to feel that deterrent effect. And anyone reading that Washington Post story will likely also think twice.
No question about that. And Joseph, we don't want that to be the outcome. But I also don't know how our viewers can understand whether there's a behavioral shift they can undergo to prevent this, because John didn't do anything for this to happen in the first place. There was no alleged crime committed. So what's your takeaway from this? If people ask you, oh, my God, I don't want to end up like John with an administrative subpoena and the government going through my email, what are you supposed to do?
Well, there's both like a practical and a philosophical issue there. In terms of the practical, you know, this isn't an isolated case. There are a couple other cases where the federal government used administrative subpoenas to go after anonymous critics, trying to unmask them on Instagram and Facebook. And the judge was going to rule against them. And then as soon as that was clear, they dropped the subpoenas. So there's no precedent that's been set that stops them from doing this in the future. From a practical perspective, you know, one can secure one's own electronics a little better. I mean, there are great privacy guides published by the Electronic Frontier Foundation, a nonprofit, and others. You have to do some serious research because the ground keeps shifting about what the best practices are. You can do these things. You can take a burner phone if you use it right, but there are risks. There are all these things you can do. You should definitely use, if you're concerned about privacy, disappearing encrypted messages such as those on Signal are much better. Email just goes too many places. Same with social media. But the philosophical question is, do you really want to do all those things?
Right.
Because part of the object is to silence dissent. And the First Amendment is the First Amendment. And if you are too paranoid, then you're giving the government a win on this. And that's That's what the people who study tyranny say. That's what not to do. You have to continue to exercise your rights as if there won't be an unfair consequence.
Melissa, is there a danger in that they go into John's emails and there's nothing here to underpin the idea that he's been any threat to anyone, but then they find something else about John that they decide to go after? Is that a fear?
It's a very real fear, I think, given the vast amounts of data that can be found by going through your email. Again, there's very little transparency around these administrative subpoenas, very little oversight. So again, in the context of the Fourth Amendment with the judicial subpoena, you have some kind of recourse. There are processes that the government is required to undertake. Here, there's less transparency and there's also a lot less oversight. And so if the government does come up with something in the context of an administrative subpoena, it may be much more difficult to be able to challenge whatever is produced and how it is used going forward. And so, I think the point that was just made, they want to deter us from speaking out and in the process to take these other steps, signal or whatnot. I mean, they're basically making an entire nation of stringer bells, if you watch The Wire. I mean, basically migrating normal communications to these other channels that we typically don't use because we don't have to.
Yeah, and Joseph, I'm sort of fascinated by this discussion because I think your philosophical point and Melissa's philosophical point is right, that we don't want to do that, but I also would like to live to fight another day. So the reason this is such a good story is because when you read the whole story, you realize you wouldn't tell John to do anything differently. He didn't write a threatening email to the prosecutor. He didn't even know who the guy was, who H was. He was just being an American citizen who was expressing his view. That said, the convenience of technology has let us all say things that in prior years the government wouldn't necessarily know that you said. So this trade-off between convenience and privacy does work its way into this discussion. It may not be that I want to change my behavior, but in case I want to live another day and not have the government hassling me, that's just a tough trade-off, because all those things that you recommend people might do if they wanted to take away some of your convenience.
Well, that's certainly true, but I think it's important to see this as a piece of the whole. The location data is being assembled and is easy for the government to get. It's easy for other people to get, even if you follow what were best practices 2 years ago and turn off Wi-Fi, all those sorts of things. The ads that are shown to you on your phone, some of them assemble your location data, and that gets laundered through data brokers into the government. And even if the government couldn't get a warrant for your location data, they can just buy this stuff on the open market from data brokers. So it's almost impossible to avoid.